Welcome, everybody. Bienvenidos.
Muchas gracias. Buenas tardes.
Hola.
Buenas tardes.
Buenas tardes a todos.
Buenas tardes.
Hola a todos.
Hola a todos, buenas tardes.
Hola a todos.
Oriana.
Okay. So good afternoon, everyone. On behalf of the Ambassador of Chile to the United States, Alfonso Silva, and ChileMass, I welcome all of you to the fourth webinar of the ChileMass Emprende series. My name is Boriana Benef. I'm a diplomat at the Embassy of Chile to the United States, and it's really a pleasure to be part of this series. As you know, ChileMass Emprende is a program organized by ChileMass and the Chilean Agency for Economic Development, Corfo, to enhance the Chilean innovation ecosystem and help our entrepreneurs improve their technologies and scale up to the US market. In this first version of the program, in which more than 50 participants were chosen to be part of the online phase, only 16 of the best will move forward to the second stage, which is coming to Boston in September for a month. For the Embassy of Chile, ChileMass Emprende is a very important strategic project because it allows us to enhance and strengthen our relationship with Massachusetts. Some of you may not know this, but Chile's relationship with the state of Massachusetts formally began in 2011, when we signed a Memorandum of Understanding to collaborate in areas such as education, science, technology, and innovation. In this almost 10 years, the relationship has been very productive. Among other things, from the Ministry of Foreign Affairs and Corfo, we promoted and supported the creation of ChileMass and the development of multiple initiatives and projects. So ChileMass Emprende is a step forward in this collaboration. But today, we are presenting an extremely interesting and useful webinar called Successfully Establishing Operations in the United States. For that, I leave the floor with the Executive Director of ChileMass, Fernanda Sosa, to introduce our great panelists. Fernanda, the floor is yours.
Thank you, Boriana. Thank you very much for this introduction. Well, how to start a business in a foreign country? All of you know that there are so many details, like which corporate structure is the best for my startup? What are the intellectual property or tax regulations in this country? Are there government incentives? The endeavor to integrate all that information for a successful start is quite difficult. That is why it's so important to find people that can help you solve all those challenges. You can mute the others. We have the honor to introduce you the best experts to answer those questions and more. We have today 4 members from McDermott, Will & Emery, an international law firm, one of the largest in the US and globally, with more than 1,200 lawyers across 20 offices in the United States and Europe. Its lawyers represent a wide range of commercial, industrial, and financial enterprises. Today, you will hear from 4 of its finest lawyers. I will say a couple of words of each of them because probably they will not introduce themselves, I don't know. So Byron Calogero is the founder of the firm's Life Science Industry Group and is the senior partner in the Boston corporate practice. He focuses his practice on domestic and cross-border mergers and acquisitions, finance, joint ventures, and alliances. He has substantial on-the-ground experience structuring mergers, acquisitions, and joint ventures on 6 continents. He has been in Santiago too. He mentioned that. Byron has an extensive industry background in the life science, industrial, and manufacturing sectors. Sarah Columbia is a fellow in the American College of Trial Lawyers. Over the last 9 years, she has led 14 patent infringement and invalidity trials across several jurisdictions, including the federal courts in Massachusetts, Florida, Delaware, California, and Texas. If you've had any problem with your patent, she is the one. Jennifer Buck focuses her practice on representing companies and investors in domestic and cross-border mergers and acquisitions, finance, joint ventures, private equity investment, and other business transactions. Jennifer has advised companies on corporate issues in a wide range of industries, including the consumer goods, technology, health, and energy industries. And finally, Robert Cordy. His practice includes business litigation, white-collar criminal defense, internal investigations, and major and private projects. Bob previously served for 16 years as an Associate Justice at the Massachusetts Supreme Judicial Court. He has worked with judges from all around the world on issues like judicial ethics, rule of law, and the American judicial system. Well, I have to confess also that I worked for Justice Cordy for almost 1 year at the Supreme Court here in Massachusetts a few years ago when I was validating my law degree in the US. It was one of the best experiences in my professional career. He's not only an amazing lawyer and a brilliant mind, but one of the most generous people I have ever known. As an example of that, maybe we can tell a little about the many delegations and important people from Chile he has received here. So for me, he will always be Justice Cordy, not only Juez Cordy para los chilenos. Well, without further ado, I leave the screen to Justice Cordy.
Thank you, Fernanda. That was very generous and much appreciated. Welcome everyone to our Zoom program sponsored by ChileMass and McDermott, Will & Emery. As was mentioned, an international law firm with active life science, healthcare, corporate, and intellectual property practices in Boston, among other places. My name is Robert Cordy, no longer Justice Cordy, just Bob. And I have been a practicing attorney in Massachusetts for 47 years. As Fernanda mentioned, I spent 16 of those years on the Supreme Court of Massachusetts, the oldest appellate court in North America, established in 1693, long before there was a United States. It was there that Fernanda and I met and had the privilege of working with her. And also the privilege of beginning to learn about your extraordinary country, which I much appreciated. And then I was privileged to host several judicial delegations from Chile in visiting our courts here in Massachusetts, including hosting the former president of your Supreme Court, Hugo Dolmesh, I hope I pronounced that correctly, and his wife in a visit to my court in Boston. Today will be mostly about Boston and Massachusetts, why it is a great place for innovative business enterprises, and how to go about doing it successfully. I will speak briefly later in the program about our courts and legal system, but first to the most important presentations, I turn it over to my partner and head of our firm's life sciences practice, Byron. Byron, it's up to you.
Thank you, Bob. Thank you, Fernanda. And again, thank you to ChileMass for inviting us to share some thoughts with you this afternoon. Yo hablo un poquito español, pero la lengua de la ley en negocios es muy diferente, so I'm going to have to stick with English. But we do, during the course of this, invite your questions. We want to make this as interactive as possible. But again, thanks for this, and let's kick off. If I can share my screen, we'll jump into our presentation. So first, again, it is a complex U.S. landscape when a company seeks to bring itself to establish operations in the United States. And it requires a whole host of different resources, some of which we've depicted here, some of which are legal, and some of which are not. The U.S. lawyer, especially the U.S. business lawyer, we view ourselves truly in that direction. In that, first, as primary, we're business lawyers, which means we need to act as connectors. And we'll talk about the role that we play. There are many lawyers who have worked in many countries around the world where the lawyer, the abogado, is solely focused on the law. The law, I like to say, the law in a vacuum is of very little value to a business person, especially establishing their operations in a foreign country. So this is where, again, we as business lawyers and U.S. lawyers try to play a broader role. Part of that is building a solid legal foundation. And whether that's raising funds as from investors or private equity, engaging in a variety of transactions, establishing, as Fernanda noted, that which legal entity to use and which is the optimum entity to use, especially when you're considering a cross-border company with great assets. I've read some great, incredible companies that are represented here. To how does one retain and attract the best talent, especially in a place like Massachusetts, where the battle for talent is incredibly important. To intellectual property, that you'll hear more from Sarah Columbia. Often your IP is we say the crown jewels of the business, and how that one commercializes that, how one monetizes that. And then sometimes I'll turn to Justice Gordy, Bob, and he'll tell you, we sometimes will scare companies with our headline lawsuits that one might hear, and the importance of managing your claims and litigation exposure, and thinking about the insurance that might back that up. To regulatory compliance, a whole host of regulatory regimes, not unlike what you face in Chile. To government incentives, which is an interesting part about how a place like Massachusetts can incentivize companies to establish operations, and finding financial incentives, training incentives to help you get established. So with that, we'll start with the foundation, and let me turn to my colleague, Jennifer Bach.
Thanks, Byron. Hi, everybody. Nice to meet you via Zoom. It's a pleasure to be able to present to you today as we kind of level and really help you issue spot, which in turn is really intended to help you both prepare for your U.S. launch or your U.S. development, and also in terms of budgeting for your U.S. operations. As we go, you all are from different types of companies and you might have different questions. We're happy to follow up on any questions you might have after this. But if you believe you have questions that could be helpful for everyone on the group, please feel free to interrupt us. We'd love for this to be interactive. I was telling Fernanda earlier, I grew up, I can see my name in the chat. I grew up in France, and I can kind of guess what you're saying, but it's not completely the same. So if you do have any questions, unmute yourselves. Feel free to just go ahead and jump in. The corporate and tax structure is a question that we get a lot from companies that are seeking to come to the US. If you have yet to set up a sub in the US, some of the questions you might have would include, when should I set up a sub? How fast can I do that? And how much does it cost? Let's start with cost, because I know that can be of particular interest. It is actually extremely cheap in the US. It's extremely cheap, and we can set you up in one day if you want to be set up in one day. So contrary to a lot of countries where you require a physical presence, where directors and officers might need to have a visa or might need to have a green card, we don't have any of those requirements. We also don't have minimum capital requirements, nothing like that. It's very business friendly, it's very fast, it's very efficient. So that leads to the next question, which is, when should you set up? If you are seeking to raise funds in the US, your future US investors will likely require a US entity. As Byron mentioned earlier, often the IP is kind of your crown jewels. And so they will want to be investing in an entity that has that holds the value, whether that may be IP or something else, right? And so ultimately that may end up being your US entity, but in any case, US investors will feel more comfortable investing in a US entity. So that is a big consideration. The second consideration would be liability. If you set up a C Corp, a Delaware C Corp, typically Delaware, but if you set up a C Corp, which is fully functional, not just a sort of empty shield company. In principle, that entity will act as a liability shield and protect your entity, your parent entity. So that would be the second kind of major consideration, especially because typically when we operate outside of the US, we see US liability as potentially being particularly high. The third
Jen,
is really just marketing. Yeah.
So Jen, what I was going to, again, I think this is one of the concerns for any shareholder that establishes operations in the States is if in fact your company is hit with a lawsuit, we talk about that corporate shield. I think as you've made clear, to the extent that, again, the company the shares are held by either an individual or another company, the benefits of the liability shield are such that the assets of the shareholder would never be impacted. So long as we say corporate formalities are maintained and you do certain basic things in terms of holding meetings and the like, shareholder meetings, board meetings, the company's shareholder, if an individual or in the case of held by a company, will never be impacted by any potential liability that might attach to the subsidiary or to the company.
That's exactly right. That shield is intended to really act as a wall. And so for that, that's one of the major reasons why, if you know you are going to be doing business in the US, if the US is one of your major markets, it makes sense to set up an entity in the US pretty quickly. If you aren't raising funds in the US or don't anticipate that, if you don't think that liability should be a driver in setting up an entity, the other reason why some companies end up setting up a US sub is really for PR purposes. I mean, I had a client who said, listen, I want to be able to present myself as a Franco-American company, and that helps me in developing partnerships and relationships in America. It makes me seem, closer to what they're used to, essentially. So that's also a third consideration.
Jennifer,
if anybody
interrupt?
Go ahead.
Yeah, someone is asking in the chat about why Delaware, because when you're outside the country, nobody understands why everybody say that to.
No, that's an excellent question, and it's a very common question. So the starting point is, contrary to what many think, Delaware is not a tax haven. The decision to is known by tax. Remember that in the US, we function on common law, which, Bob Cordy can talk about a little bit more, but one major consequence of that is that a lot of the rules are set by the court, as opposed to our civil law countries where they are predominantly set in a code. And remember that the US is federal, so we function on a state-by-state basis. Bearing all that in mind, Delaware has, I would say, the most sophisticated business courts in place. One of the main reasons for that is that a lot of the judges there are former businessmen and businesswomen. So as a consequence, the laws that are set forth there are business friendly, they're sophisticated, they're logical, they're advanced, and the rest of the states tend to follow Delaware law. Remember that the state in which you incorporate is the state that will govern your internal structure. So if you incorporate in Delaware, that means that your internal structure, your internal corporate governance will be subject to Delaware law. Now remember that if you're doing business in other states, you also have to register in those states. So that leads to the question, what does doing business mean? Doing business can be anything from having an office to having employees or personnel. It's determined on a state-by-state basis. But one way or the other, if you are present in other states, you might need to, in fact, register in those other states. So for those reasons, often companies opt to incorporate in Delaware to ensure that they can benefit from Delaware rules. all while registering in the various states in which they do business. Did that answer the question sufficiently?
Yes, I think so. Yes, thank you very much.
Yeah. And then I think we have another question.
Yeah. It's the one in the chat, no?
That's a Sarah.
Yeah, we can get to that when we get to Sarah.
We can get that when we get to
Yes,
IP, yeah.
it's regarding patents, so maybe Sarah, I don't know.
Why don't we finish, Jen, why don't you finish
Well,
up and then we'll
I
move
mean,
to intellectual property.
Yeah, I was gonna say, IP is our next slide, so we can certainly move on unless anybody else has any questions around corporate formation, US establishment.
Okay.
All right, I don't hear anybody.
Okay, we'll move to intellectual property, if I can make that move. Sarah?
Sure. Hi, I'm Sarah Columbia. Thank you for that nice introduction, Fernanda. And I practice in the area. Most of my practice is involving disputes over intellectual property, but I also advise startups and other companies on protecting their intellectual property, as well as making sure they have freedom to operate in the US. The questions are coming in the chat in Spanish, and I apologize, I don't speak or read Spanish. So if there are specific questions about IP, it would be helpful if someone who has both languages, which I don't have, can make sure I get them. As a general matter, I took a look at some of your companies. It looks like some very exciting projects and exciting businesses, and a lot of them seem to involve intellectual property of one form or another. Many of them seem to be somewhat technical, and I can talk a little bit about your patenting strategies, not specifically, obviously, because today is not an opportunity for one-on-one legal advice, but some general principles. And then sometimes people focus hard on patents and they forget about their trademarks, which is also very important. And depending on what you're doing, copyrights might also be significant. The US system, as probably most of you know, has a national standard for patents and trademarks, a little bit less so for copyrights, but I'm going to focus mostly on patents and trademarks today. So that means that you need to secure your patents and your trademarks with the United States Patent and Trademark Office, regardless of which state you are in. It's one system and it's national. So unlike the challenges that Jen just described about, having to go state by state for certain corporate points, the patent system and the trademark system are national. Okay, and I will answer the question that just came in. We're going to focus first on protecting your own IP. If it's protectable with a patent, meaning it has utility and it's novel, you should certainly consider whether investing in a patent or more than one patent is a good investment. Usually that's the strongest way to protect your technology, assuming it's protectable. Sometimes the cost and expense and length of time to obtain a patent is not worth it, and you're better off to protect your technology as a trade secret. But that's, if anybody's particularly interested in that, I can talk about the pros and cons of trade secret protection versus patent protection. Patents are in the US are, you know, a relatively expensive investment in both legal counsel, but also in time. On average, it takes between 2 and 3 years of effort with the United States Patent Office to obtain a patent. But as I'm sure Byron will tell you when it's his turn, your investors like to see patents. So patents can serve many purposes. They can serve the purpose of that they're intended for, which is to actually protect your technology against other competitors who might want to use your technology. But they also can serve the purpose of demonstrating to your investors that you have patentable technology and that you've taken the steps to protect it, such that you're protecting their investment in your future, if you will. I've got to note that it's important to align your strategies for protecting your intellectual property assets with your US market strategy and business strategies, and in some instances, regulatory strategies. We often find companies, particularly startup companies, who are very anxious to get a patent, but don't think about how that patent and how the way the patent is drafted and how the claims to the patent are drafted in a comprehensive way that takes into account their marketing strategy and their business strategy. And so one of the things that you'll want to do if you have technology that's protectable is make sure that not only your scientist or your technology person is involved in the patent strategy, but also your business people are involved in the strategy.
Sarah, if I could interrupt for just a second, I just think about a great example of that. We mention up here the FDA, the Food and Drug Administration. And in the world of medical device, there's a regulatory regime that allows one to get what's called the 510K that maybe GeoBone might be interested in, but it relies on what's called a predicate device. So the application that I would make to the FDA would say, I can bring my device to the US market because there's a predicate device. There's a device that exists currently in the United States that's been approved by the FDA, so let me in. That runs counter to what Sarah on the intellectual property side may say, is that I'm filing a patent that is new and novel. That is, and it's so when I make the patent argument, I say this is the first of its kind. No, nothing like it. Notice how that runs contrary to the application that I've just made to the FDA to say I have a device that's similar to others in the market.
Yeah, that's a great example, Byron, and that's the reason I put the regulatory piece up here, because you know, the good news is often startups are relatively small, so you don't have too many people involved, but you might be wanting to say things for regulatory purposes. The 510K is a great example, that you just want to be careful how those align with what you are making in representations to the patent office in order to make your case for your patent the most strong.
And Sarah, just another question. If I'm one of these companies that has a patent registered, issued in Chile, and I desire to enter into the US market, what should I be thinking about in terms of my patent strategy in terms of entering the US market? And I think going to the question of if I then seek to out-license my patent, for example, to an interested third party.
Sure, and I think that's the question that's on the board there, Byron. Thank you. So a couple of things. One is you can only enforce the patent in the country where it's in force. So having a patent in force in Chile by itself will not be of any value to your entry to the United States. Normally, the most common thing to do is take advantage of the international patent treaties that permit you to file your first application, for example, in the United States, and then you have 1 year to nationalize, what we call nationalize that application in other countries. So typically, not always, but typically, the largest market is the US. So very often companies will file their first application in the US and then decide in that 1 year which other countries they want to make sure they have protection in. Europe has a unified system, so you can, it's a little bit more efficient. Otherwise, it's country by country. Sometimes for economic reasons or just because they're not sure where they're going to be focused, companies do it the other way around. So it would not be uncommon if you are starting your company in Chile, for example, or any other country, to file your first application in that country. So for example, in Chile, and then use that application to nationalize into the United States, but you have 1 year to do that. If you have not done that, if you have simply obtained a patent in Chile and have not filed what's called a counterpart application in the US within that 1 year period, then you have to start over again in the US, which can create issues because when you start over again, you start with a later invention date, essentially a later priority date for your invention. So best practice, which sometimes my clients, it's too late by the time I give them this advice, but best practice would be to think from the beginning which countries you expect to do business in and where you want to protect your inventions, and have a strategy from the beginning. Either you start in your home country and then you expand to other jurisdictions, or you start, for example, in some place like the US or in Europe, and then expand country by country from there. The last bullet here was about life cycle management, which is sort of a similar concept. You want to think from the beginning, particularly with inventions that are going to take a long time. Usually this would be in the pharmaceutical or medical device or other highly regulated industries. If you have intellectual property that is going to take a long time before it can get to market. The classic example would be a pharmaceutical, which has to go through the entire FDA process and clinical testing and all of that. Oftentimes, by the time you get through all that, you don't have very much term left on your patent. And so strategizing from the beginning on how to maximize, I'll say, the life of your patents can be critical in terms of medical device or pharmaceutical or any other market, any other market situation where the time from the date that you make the invention to when you actually get to the market is going to be an extended period of time. I would move now to freedom to operate unless there are other questions. How much? Oh, how much time does it?
No, Sergio is raising his hand. So he wants to ask something.
Oh, yes.
Yes, thanks. I am Sergio Garcia from La Serena. And first of all, thanks for this nice presentation, very useful information. And I would like to ask if one member, one founder of my team or my entrepreneur have problem, for example, with a previous default. If one person have been in default here in Chile, bankruptcy, there is a problem in United States to become a founder also for this new company?
Byron, do you want to take that one?
Sure. No, I think that the question will come, for example, when one is doing due diligence, and we'll jump on that in a few minutes, but while we often we say our investors will invest in the technology, they're really investing in the people because those are the individuals who I'm investing in to eventually commercialize. So I'm investing in people and technology. Sometimes the technology leads me in, but it's the people that are most important. So when I'm looking for an entrepreneur, and I'm going to do my due diligence, and I'm actually doing one right now on a company where I have a client who's investing in them. We're looking at the founders, and so we'll do background checks. And so if I do a background check that says, okay, I've got a Chilean entrepreneur founder who I'm investing in because he's established a company, got some great technology in the States. So I'll go, if I've done my diligence well enough, I'll reach out to my friends in Santiago, and I'll say, please do the background check. They'll come back and they'll say, this individual had a bankruptcy. Does that mean that I don't invest in the company? No. In fact, some will argue that some of the best entrepreneurs are the ones who have failed.
That's what we think of Donald Trump, isn't it?
So I think that it's important to understand the background of the people, and I think the most important thing, the lesson from this is transparency. I say transparency equals trust. Es la verdad, es verdad. Because if you don't know, if you try to hide something, Jennifer's going to find out. Bob, I'm going to find out. At which point the trust is disappeared. So it's a great question. But I think but that's not I'd like to understand why. I would ask the questions, why did you go bankrupt? What happened? So understanding that, the diligence is important. We'll talk about that in a couple of minutes. Good question.
Right.
Thank you for raising it.
Thanks a lot. Very clear answer. Thanks.
Okay, Sarah, back to you on FTO.
Okay. Yeah, and there's a question on the board of how much time on average does it take a medical device to be approved by the FDA? I actually don't know the answer. Do you know the answer on that, Byron?
I think, again, it's going to be depending on the nature of the device. As devices become more invasive, it will what's called requires a pre-market authorization, which is a longer period, could take years, versus I mentioned the 510K, which is a class 1 device, which is, again, to the extent that there's, and I apologize for the terminology, there's a predicate device, something out there already, doesn't require clinical testing, then it might take as little as 3 months. It all sometimes depends on backlog, but we're happy to answer more questions, specific industry questions, separately if that's helpful to some of the attendees.
Yeah, and maybe I'm just going to unpack that a little bit, Byron. So in the U.S., if you're relying the predicate device, that's not it's not a concept probably we use, but what that just means is you're relying on someone else already having gotten approval for a very similar device. So if you're able to rely on that prior approval of a similar device, that can really shorten your time through the FDA. And that was what Byron was talking about with the 510K process. If, on the other hand, particularly if you're dealing with an invasive device, and you're brand new, you're not relying on the work of someone else, then you've got to do your clinical testing and safety and all that, and that can take years easily. Let me talk a little bit about freedom to operate, which is the second sort of big thing you need to think about with intellectual property if you're coming into any new market, including the United States. But of course, we know the United States, and that is how do you look out across the landscape to see whether anyone else has intellectual property protection that might prevent you from selling your service or product. or even worse, that might come and sue you after you sell your service or product and start to be successful for patent infringement or trademark infringement. And this is really, really important and something that requires your attention, because for two reasons. One is you don't want to invest and get ready to go to market only to find out the hard way that someone else has either a patent or a trademark that is going to either prevent you from selling or be used to sue you or threaten you with suit. So this is one where it's much better to know what the landscape looks like. And some of this you can do yourself, some of it you can hire attorneys to do. But yeah, there are databases that you can use to do searching, to develop freedom to operate landscape analysis so that you can judge whether there is a real risk that you could be blocked from selling your service or product. And then if you do find something that's going to be a challenge or could be a challenge, you can think about, okay, can I work around it? In other words, if it's a trademark, are there things I might change in my design so that I'm at less risk from the trademark? Or if it's a patent, are there ways I could adjust my product or service that would avoid the patent? So those would be important, what we call design arounds. If not, then you might need to consider whether you could approach the owner of the intellectual property for a license. Very, very important to do that, and very important also to do it in the context of your competitive landscape analysis. What we find, and this shouldn't be surprising, you usually don't find out about other people's IP unless you go looking for it until you get successful. So, let's say you have a catchy trademark or a catchy name. No one might notice, but if you start to be very successful, then you get people's attention, and that's when people start to pay attention. So you want to make sure that your commercial strategy and what you know about the competitive landscape is informing your IP strategy as you think about this freedom to operate question. And those are the sort of, it's a very high level description of how you should be thinking about your IP questions. I did see a question on the board about how to pick a law firm in Boston. It's easy, you just pick McDermott. No, that's not true. But I do think through this connection that we have with ChileMass, we can help individual businesses find appropriate counsel in Boston. Sometimes that could be McDermott. Sometimes we would be happy to tell you we're not the best fit and help you to find other law firms. It's also not a bad idea to talk to other entrepreneurs and find out which lawyers they are happy with and understand their business.
And I think, yeah, the understand your business point is a good one, Sarah, in terms of having industry expertise, and we'll talk a little bit about this later, having connectivity to providers of capital. But again, I think you should look at whether it's your accounting firm or your law firm, you want to develop a relationship. And again, while we're a large firm, there are different programs that we have for early stage companies. We can talk a little bit about those as well. So there, obviously, price is important. Connectivity, industry knowledge, incredibly important. But thanks for that advertising question. We like it. Why don't we, Sarah, just run over to due diligence. We talk about due diligence, and this is a term that if we hear on a regular basis. But as I mentioned earlier, in response to one of the questions about, the intellectual property is often the asset that's going to attract investment. It's going to attract interest. You tell a compelling story because you have intellectual property that's been developed in Chile through one of the universities, through one of your entrepreneurs, that is compelling. So if I'm the investor, if I work for a VC firm or a big company that says, hey, this is pretty interesting, this could be somewhere I want to invest, I'm going to due diligence. And it's DUE diligence because it's getting deep into in particular, the intellectual property. And for that, I would, again, turn to somebody like a Sarah to say, tell me about the strength of those patents. And maybe, Sarah, I know you've touched on it to some degree, but just give it a quick view in terms of being able to tell that story to a potential investor.
Yes, and Byron and I actually work together quite a lot in this way. What someone like me would do is really look at the patents or trademarks for that matter, look at what you've done, if you've done anything so far in terms of freedom to operate, and help you to present to your investors a truthful but strong story about the strength of your IP and why we think it is a solid foundation and protection for the asset that you consider to be sort of the core of your company.
And we like to say, begin with the end in mind, which means if you're going to enter the US market, you want to know who my potential competitor, clearly you want to know the competitors, and you do that in your pitch. I'd like to know who your competitors are, who are my potential acquirers, who might be interested in acquiring my company, or who's my potential collaborator. So those are incredibly important in terms of, again, we talk about the IP being really the hook that's going to attract potential investors, buyers, joint venture partners, or companies that you're going to use to commercialize your product. We'll jump to and we'll look at some of these questions as they come through. And there's a couple of med device questions I'm happy to answer as we get a little further in, and happy to follow up separately as Jen noted. So let's talk and just continuing that. A lot of companies come to the U.S. They come to Massachusetts and they come to Boston in particular because, as the bank robber says, I go to banks because that's where they have the money. And in fact, in Boston, there's a lot of money. We have a very active venture capital community. We have a very active and robust private equity community. And for so many industries, there are significant corporate players that are looking, that have the money. So it's important in terms of going through that process, whether you're a company that is looking for, we say in the VC world, the venture capital world, a Series A investment, or again, when we talked about potential acquisition targets, it's important to package up your business so that when I start asking these questions, tell me about your corporate structure. Tell me, I want to look at your minute books. I want to see what the patents and trademarks are. I want to know how you retain your employees. This is the full package. And when we say reverse due diligence, that's when I represent a company that wants to make an investment or an acquisition, I'm going to send you a 10-page checklist of questions that I want to see all the paper behind this. And then I'm going to have a series of questions with your executives that I'm going to follow up with. So it's important, we say, when you're representing the company, to do reverse due diligence. Look at yourself. Look at a due diligence checklist in terms of what the questions are that are going to be incoming. Because part of what you want to signal is you have your act together. You have it all. You don't say, well, let me look around, see what kind of paper I find. No, that's not going to be helpful. You want to have your business packaged up well. So packaging is important. Financing, again, we talk about the partners, whether it's a venture capitalist who knows your industry, who's had success, whether it's a strategic. And I do a lot in the medical device world, and I might say, hey, this medical device company wants to invest. You might have a corporate venture capital arm, wants to invest in my company. Well, guess what? If I let that company in and they invest in my company, then I may have foreclosed other med device companies in the space from investing. So you have to think about, I want to take this investment because they might be the right distribution partner. They might have an adjacency in terms of the product that could make mine more successful. Banker relationships, as well as lawyers, we have, it's important we say, the bankers we talk about here are the investment bankers. Similar to your lawyer, you want the bankers who know the industries, who know cross-border transactions. So it's important, and your lawyers should help introduce you to bankers. We work with a variety of different bankers, and they, depending on the stage of the company, they recognize, as we do, that you need to nurture these companies along. Sometimes they might not be at the right stage where the banker can go out and seek investment, but sometimes you find the right bankers who will say, here's a company that I can follow, that has interesting technology, good people, successful serial entrepreneurs, or when we see the doctor entrepreneur who's made the successful transition, or so it's again, finding the right bankers is important. Again, the last one we'll talk about is the Delaware Flip, which sounds like a gymnastic move, but that's a situation where you might have a Chilean company, and if I talk to my local venture capitalist, he says, with all due respect to Chile, you've been to Santiago, it's beautiful, but he said, I want to invest, as we talked about the Delaware company, which goes to that earlier question. So in that case, there's actually a transaction where your shareholders would contribute to a new co, and your parent, the parent company, then becomes the Delaware company. So it may be that the Chilean company becomes the subsidiary, and the shareholders of that Chilean company become the shareholders of the Delaware company, the new parent of the subsidiary. We call it a Delaware Flip, because again, you'll find U.S. investors that will often want to invest in the U.S. vehicle. That's where the assets are, through the subsidiary in this case. Jen?
Byron, if I can just add on the investments. One of the questions we get quite often with non-U.S. companies that are coming to the U.S. to raise funds in the U.S. is when they should do that Delaware Flip. And remember that the Delaware Flip is not necessarily the only option that's out there. There are alternatives to that as well. But in any case, the question is, when should we set up our company structure to be U.S. investor ready? Typically, what we would recommend is to not do it early, in advance of understanding what the investors want. Like I said, a Delaware Flip might be what your U.S. investors want, but other U.S. investors might prefer different structures, such as transferring the IP from one entity to another, which you would do at a very early stage, or licensing IP is even another alternative. And so in order to avoid kind of wasting time and wasting money as well, from an investor perspective, typically what you would present is the option of becoming a more US-centric entity or company group. So you would say, here's our current structure, we have a US subsidiary, we are ready to change that around based on what you want as a closing condition. So we are ready to complete a Delaware Flip or any other alternative that you might prefer. Just make sure that you leave the door open so that your investors know. One thing with investors that I will say, having been actually on the investor side, is sometimes when there are key issues like that for investors, they might actually not even ask you. They might not say, hey, are you considering changing to the US? They might automatically dismiss the idea of investing with you on that basis. And so it's important to be upfront and say, here's, we're working with McDermott, and here's what we would do if you wanted a more US-centric company. That way you just don't close any doors to any potential investors.
Sure. Because there might be foreign investors in particular. You might have a whole host of questions that go into that. Good point. The question that came back from Javier Ramirez in terms of city or state advantage for a biotech startup that wants to be incorporated in Massachusetts. Again, I think that what we've had in Massachusetts and over the last 10, 20 plus years is that more and more biotech companies have been coming to the States. Companies like Takeda, which acquired Shire, coming to the States. Companies like Biogen, Sanofi, Merck, have all come to Boston, all headquartered in Boston. Huge numbers of biotech, life science companies in Boston. And that in terms of that ecosystem is so important in terms of being able to attract investments and being on the ground. I think at the appropriate time in terms of establishing a presence in and walking the streets. It is important. Again, we're doing it via Zoom now, but to be out and in the city. Now, people say, I have a lot of overseas investors that come in, or overseas companies that say, I want to be in Cambridge, Massachusetts. I said, great. Let me introduce you, we'll talk later on, to my friend who's the real estate broker. And then you look at the cost per square meter of lab space in Cambridge. And suddenly you wind up in places like Waltham, Woburn, Worcester. And there's a number of other cities that seek to incentivize. So we've recognized that Cambridge is a great place to be, very expensive. But depending on what you're looking for, there's a number of other cities, and we'll talk about incentives because the other piece is you want to be able to attract those employees who can easily commute to your city. So great question. Speaking of employees, let me turn to Jen again.
Yeah, thank you, Byron. Starting point really for those who are considering coming to the US and hiring in the US, be mindful of how competitive the market is. We really have the concept of freedom of market in the US, which has so many benefits to it. But one of the consequences for employers to remember is that means that your employees can easily jump around from one company to another. So what does that mean for you? From a strategic standpoint, two key things. First is, as you're thinking of immigration, I'm not an immigration attorney, so I'm not going to get into visa questions and the like. But as you're thinking of it from a strategic standpoint, remember that your US employees have full freedom to operate and jump from one company to another. And their compensation is going to be based on what is market. Now, what is market in Cambridge, as Byron suggested, is significantly higher than what is market in other states. On the other hand, the employees that you bring in from your country or another country might be cheaper, and they might be more faithful, again, because they're bound by you via visa. And so you need to think of that when you're considering who should we bring over and who should we hire in the US. The people in the US might bring a cultural aspect that you're looking for. They might bring a book of business and contacts that you're looking for. People from outside the US might bring expertise and specializations that are hard and expensive to find in the US. So that's number one. Number two, in terms of competitiveness, is what you're offering. To the extent you are, in fact, going to move forward with employees, remember that despite what we tend to think outside of the US, although a lot of our benefits might be optional, you need to offer those types of benefits in order to attract. So although we do have the strict minimum of what you might want to, the strict minimum state requirements, again, it's a state-by-state basis, you might want to think about also offering health insurance, dental insurance, retirement, and items like that. It is not because it's not mandatory that it is not common practice in the US. That all being said, as you are kicking off in the US, you might not have the budget, or you might not want to fully dedicate yourself to employees. An alternative for you might be hiring independent contractors / consultants. As in most countries, if you are going to do that, you have to remember that you need to treat them different than employees. You don't have full control over them. They don't dedicate their full time to you. If that type of relationship begins to establish itself, an independent contractor could be reclassified as an employee. But the advantage of an independent contractor for you as you come here is it allows you to test out somebody perhaps before hiring them full time, and also to incentivize them. Often independent contractors are really compensated on an incentive basis. For example, you could set milestones. If they achieve those milestones, then they get their compensation. You can keep them, interested and incentivized in the long term. So it's an awesome option as you get kicked off in the US, as you're not really sure about your various contacts here yet, and as you're seeking to also be mindful of your US budget.
Yeah, I was going to say, Jen, that you've got in some cases in terms of hiring a back office for chief in terms of your financial affairs, accounting. It's possible to outsource certain of those functions on the front end. So when one comes in, you're really bringing in key employees, scientists. I'm going back to the life sciences, but key employees early on. Some of those functions you can outsource to make your life easier when you're establishing operations.
And remember too, in terms of key employees, to the extent you're bringing in employees at kind of the executive / management level, the use of equity is very common in the US. And that is something that your management level employees will be expecting and should be offered up front, which is a little different than in many countries. But that's another item to bear in mind. The final point, which is kind of that first bullet point actually on this slide, is the professional environment. From an employment perspective, there are, I would say, much stricter rules in how one is to behave in the workplace than tends to be the case in other countries, especially non-common law countries. A lot of sensibilities here, a lot of items to be mindful of. And so what that means is you need to make sure you have a good internal policies in terms of the workplace environment. You need to make sure that you put in place good trainings, and you need to just generally be mindful of the difference in cultures between one country and another. And this is something, when I present to my European friends, this is something we have to sometimes spend some time on and go through specific examples for. But it is somewhat of a cultural difference that needs to be accounted for. Often the first kind of difficulty, I don't want to say lawsuit, but difficulty that companies, non-US companies have, but also US companies have as they're growing, is specifically with employees. So that employer-employee relationship, although not a very sexy one as you're trying to focus on other bigger things, is something that you definitely want to bear in mind.
Except I probably wouldn't have used the word sexy. That's right, Jen.
Yeah, right.
And then in Felipe, in response to your question, we're happy. We'll send out an example of a due diligence checklist that Fernanda can share with the group. So let's jump to the next, which is regulatory compliance. Jen, you're still on here.
Yeah, so regulatory compliance, I won't spend a lot of time on this because it's really specific to each company depending on what you do. So what you see on the screen are some kind of key points that you need to think about. Regulatory compliance is not only at a state level, but at a federal level as well. And so as you see some examples here, antitrust, trade compliance, those are really at the federal level. Trade compliance, I just want to spend a little bit of time on, because in terms of issue spotting, I think this can help. To the extent you have a physical product that is going over the border in one direction or another, you are subject to US trade compliance rules. That should be your general rule to keep in mind. The sub rule of that is as follows. If you are dealing with highly sensitive information that could potentially affect national security, and you share that information with a non-US citizen, that might also be subject to trade compliance rules. It's a very easy topic and frankly, a non-expensive topic to address, but sometimes companies tend to put that one on the back burner. And just like with taxes, you could probably get away with mistakes for a few years, but once you get caught, the consequences are just very complicated because you're dealing with the government and you're trying to mitigate penalties and your product might get seized and now you're in breach of contract with your counterparty because you're not delivering and the like. So please bear that in mind, especially for all of those who have a physical product that they'll be shipping one way or the other. Of course, there are going to be all sorts of industry-specific regulations. Byron's been giving a few life sciences examples. The FDA is a big one here, but not only. I saw, there are some energy-related companies interested in coming to the US. All those items should be addressed with consultants and or lawyers who are specialized in that specific industry. One of the things I love about our FDA practice is that it's led by somebody who used to be at the FDA. So they know the FDA in and out, they know how they function, they know have they analyzed cases in the past, and they can predict how it will be done in the future. And that's kind of the benefit that you get in working with experts in these really industry-specific types of areas.
And Jen, the other one that I just wanted to highlight for the group is we talk about extraterritorial. What we mean there is if in fact you become a US company, let's say you do the Delaware Flip or operate in the United States, certain of our laws extend beyond the border. The one that you hear a lot of is the Foreign Corrupt Practices Act, which means it's really an anti-bribery law. It's kind of like the clean company laws in Brazil and others, in maybe in Chile and elsewhere. But it's an anti-bribery and corruption law that will apply as a US company to the extent your Chilean subsidiary was engaging in foreign corrupt practices, which typically means, again, bribing a foreign government official in return for commercial gain. You're then violating a US law because of the extraterritorial reach of some of our laws. But we don't want to scare people away. We say the perp walk at the end. It's always, sometimes we'll put a picture of somebody wearing a suit and handcuffs. We don't want to scare people away, but again, just it's important to recognize the regulatory regime in any country, but so that you stay out of trouble. Doing deals and we want to keep on track. Timing wise, again, when you're entering, you do it in Chile, you do it in the States. We talked briefly about the civil law regime versus the common law regime. Again, common law being based on the accumulated decisions from a court for which we respect precedent, whether those accumulated decisions by Justice Gordy and the like, versus a civil code country like Chile that follows a civil code. What that means generally is that when you look at a US contract, it's more detailed. It's longer. As opposed to being able to rely on the civil code, you now have contracts that are typically more complex. Unfortunately, I think the US impact on global commerce is resulting in more complex contracts on a global basis, but It's important in terms of the contracts that you enter into, whether it's you're buying goods through a purchase order, you're selling, and you need the invoice with your terms and conditions. Again, they're relatively standard depending on the nature of the business, but important to have good contracts in place. When you get more complex, whether to the extent you're hiring a distributor, you're supplying product, you're hiring a representative to sell your products, again, you want to have good, clean contracts that set out your rights and obligations. And then there's specific industry agreements as well, again, for which your lawyers should help you, that speak to the governing law and to the oftentimes the court, sometimes arbitration that addresses those. The larger contracts, more significant, again, whether it's a joint venture, again, typically where either a contractual joint venture, where the contract sets out the rights and obligations of the two parties that are collaborating, or an equity joint venture in which you form a company and the governance documents set those rights and obligations in that document. Obviously, mergers and acquisitions when you're buying and selling a company, and licenses and collaborations where you're not selling your rights, but you're licensing certain rights to a third party to commercialize, whether it's in licensing, where I'm the beneficiary of those rights and obligations of that technology, or out licensing that technology. Apologize for running through that pretty quickly.
And actually, just one little point on this, again, because we're common law, remember that freedom to operate comes with a lot of responsibilities. And one of the benefits of it is that you have full freedom to negotiate what you want. So contrary to a lot of other countries, we don't have kind of those fallback protections if you end up not negotiating something and properly negotiating something, or negotiating a bad deal. All that to say that beyond one of the consequences being that your contracts will be longer and more detailed, another consequence is you need to ensure that you get all your team members who need to be involved in negotiations involved early, and that would include your attorneys. It's not like in some countries where you can kind of get through the term sheet on business terms and then start a contract and then ask the attorneys to review the contract. You want to make sure you're consulting with all your proper team members, including your attorneys, at a very early stage, preferably prior to the term sheet, because you don't know what you're not negotiating. You don't know what you might be negotiating wrong, and you might not necessarily know the consequences of certain items that are negotiated. It's in the US, we've had case law that interprets, provisions based on a comma. If a comma is misplaced, that might affect what your sentence, how your sentence is interpreted. So, again, remember that an early involvement is necessary. What was that? Sorry, it's cutting in and out.
Sorry.
Just
No
want to say.
Okay.
But before you move on to the next slide, there's a little question on the bottom on C Corp. To maintain your C Corp is just a few $100s every year. It's very cheap.
Yeah, good. Okay, now let's turn to Bob in terms of, again, we didn't mean to make Bob the bearer of bad news, but he's always so cheery. And now we're going to get him to tell us about claims and litigation, lawsuits that might impact your company and how to protect yourself. Bob?
Well, Byron, am I on? I can't see anything.
Now
Can you see me?
We can see you. Yes, sir. Go ahead.
Well, let me tell you what I know. There are both state and federal courts in Massachusetts. About 90% of all the cases that are filed in courts here are filed in state courts. But patent and trademark cases are exclusively federal court cases. I have worked with judiciaries in more than 30 countries around the world on improving their legal systems, and can tell you honestly that both the state and federal judges here in Massachusetts are among the very finest. They're selected on the basis of merit and usually only after at least 15 years of practicing law. When I was appointed to the Supreme Court of Massachusetts, I had practiced law for 27 years. So I had a pretty extensive record to be analyzed and hopefully demonstrated proficiency. Once appointed, Massachusetts state court judges serve until age 70. Federal judges serve for life to ensure their independence. Corruption in our court system, at least in Massachusetts, is almost unheard of. And the judges are not only intelligent and experienced, they are impartial and not subject to undue influence. All of this is good news, I think. But, and this is important, our legal system is based on respecting precedent, common law principles. And our appellate courts are there to ensure that precedents are followed by all judges. Only the Supreme Court of Massachusetts, for example, can change or modify precedent in state law, and only when there is a compelling need to do so because of changing circumstances in our business and social communities. A precedent-based system is very important for businesses here because it allows them to know how the law will likely be applied to them, and they can plan accordingly and with confidence to avoid legal pitfalls and lawsuits. Of course, it's best not to get embroiled in litigation in the first instance, but it happens. And that's where insurance can be extremely important. Liability insurance for the company and insurance for the officers and directors of the company are critical, especially if you want to appoint directors who will bring expertise to your company. Having insurance for your employees who might be injured, called workers' compensation insurance in this country and in Massachusetts, is legally required, above and beyond just liability insurance for the company generally. So having a first-class, knowledgeable insurance advisor is therefore an important early step if you plan to set up a business here. Good legal advice, of course, is also critical from the outset, as I hope you can tell from the presentation so far. And Massachusetts recognizes the important concept of attorney-client privilege, which protects from disclosure conversations you might have with your chosen legal advisors and the legal advice you receive from them. So, I could talk about these elements for days, but will not do so and turn it over to the experts that are more important to your business futures. Thank you, Byron.
No problem. Let's thanks for that, Bob. Look, just Jen, we'll talk a little bit about government incentives. I mentioned it earlier that if in fact you are coming into Massachusetts, there are a host of government incentives that can help you in terms of getting established. And they may run from job creation to research and development credits to helping you purchase machinery. Massachusetts recognizes the importance of supporting businesses, and these opportunities and incentives can come at an early stage. Jen, why don't you talk a little bit about workforce training and other financial incentives?
Thanks. Yeah, these incentives the incentives that are available to you, first of all, are going to differ based on the level of development of your company in the US, the size of your company, how much you've invested, how many people you've hired, and the like. So you certainly should be looking into whether you have access to government incentives when you're coming to the US. But what you shouldn't forget to do is renew that search as you grow. So if, a year later you end up with 10 more employees, you might be ready to benefit from some additional incentives. The incentives can come at all levels of government. They can be at the town level, or city level, state level, as well as federal level. And beyond that, you might be able to also get industry-specific grants as well. This can be free money. There's nothing better than free money. It's second in line after free legal advice, which you're getting right now. But it can be free money. It can be, you know, Byron was mentioning earlier, sometimes companies that come in and they say, hey, we want to be in Cambridge. We want to be here for X reason. But really, you might be able to get significantly more incentives if you're slightly outside of Cambridge or outside of downtown Boston. You know, I have one client who came here, and go ahead.
Oh, no, say, or put those companies and put those municipalities or cities in competition for your workforce.
That's exactly right. And they'll help you if you're coming here to build, if you need, you know, a lab, or you need space, or you know, you need a little more than what the downtown / Cambridge area has to offer, for example. The different towns will work with you to help you find good office space, good lab space, help expedite permits, those types of things. So it's really valuable and something to keep in mind, especially in Massachusetts, as we are just extremely competitive, strong economy, booming, a lot of companies coming. Towns are in competition with each other. And so Byron's 100% right. You can put them in competition and kind of leverage that. But the incentives might take, you know, all sorts of forms. And again, it depends on your industry, where you are seeking those incentives, what town, what state, and the like. And also your size. And I'm sure that ChileMass probably has resources there to help you as well as you're thinking about these different incentives.
Absolutely, yeah. There's what we say non-dilutive, especially early stage companies, non-dilutive funding out there that's available.
Yeah.
And you should, again, I think the key is start negotiating early and use resources like law firms and others that can help you. There are places like the Mass Life Science Center, again, I speak life science again, but a whole host of organizations that can help you navigate this and find some incentives. Let me, I know we're
and
running.
actually,
Oh, sorry. Go ahead, John.
if I may, Byron, I know that Sarah on the line with us unfortunately has to drop, so I wanted to give her a few minutes before she drops, and also allow anybody on the line who might have IP related questions to take the next couple minutes to ask her any questions if there are any out there.
Thanks, Jen. I didn't see any more in the chat, but if anybody has any, I'm sure that Fernanda can help you find me, and I'd be happy to, you know, direct you to the right resources. And thank you everybody for joining. Sorry to have to drop before we're all the way at the end, but it's been very fun. Thank you.
Thank you, Sarah.
Hey, Sarah.
Thank you so much.
Hi, Sarah. Thank you.
And I think we're just about done. I think as I mentioned earlier to start, again, you should look at your U.S. lawyer, whether at McDermott or otherwise, as a solutions provider. So I apologize. I'm gonna when these clients call, but I'm gonna see if I can. Sorry about that. But look at your lawyer as a solutions provider. In other words, they're again not just there for the law. We're business lawyers, so we see ourselves as hubs, as connectors, as a concierge. If you're looking for Red Sox tickets, you talk to Fernando, you talk to me. But if for our baseball team, but we can help in a lot of different ways. And it's the goal of your firm should be to reduce the level of friction when you're coming into a foreign country. All kinds of different obstacles, but your firms, your accounting firms, your law firms should help you. And we're also a connector, again, whether it's a commercial partner, transactions, government agencies, capital sources, and beyond that, I think McDermott has created a bit of a network so that we have certain preferred providers. So when you're establishing your business, whether it's an insurance broker, a recruiter, a back office firm that's doing your finance work, again, these various different agencies that can help you navigate. I'd say the benefit of a place like Massachusetts, Fernanda knows it, is that we believe in the karma of connectivity. In other words, I help you, you're going to help me, my reputation's enhanced, and we like to see companies successful. Massachusetts has an incredibly vibrant international community, and I think that's the reason we do these presentations, is because we recognize the value of that. We look forward to welcoming you to Boston. We like the competition that's going on here, and hopefully by September we'll be able to give you a view from the tallest building in Boston, and be able to meet a number of you in person. But with that, we will, again, I think that we've given you the song and dance about McDermott. That's our global footprint. But most importantly, there are a number of questions that came through, specific questions that we're happy to answer. We're happy to provide if it's not there, we will get it to you. But we do have a variety of programs that we provide on a global basis. Some of them are listed here. We'll make sure this presentation gets out to you so you have a copy of it, and then you'll have our email contacts as well. So with that, Fernanda, I'll turn it back to you. But again, we thank you for the opportunity to present to this group. I'm so happy. Sometimes we'll say preguntas, and nobody will say, people won't answer or ask any questions. But this was a very engaged group, some incredible companies out there. And to the extent we can be helpful to you going forward as you establish in the States, we're more than happy to talk. Thank you.
Thank you so much, Byron, Jennifer, and Bob Cordy, and Sarah that she already left. So thank you so much. It has been really amazing presentations. There are so many questions that are not yet answered, but I think we will have time in our next office hours also to discuss those questions in more detail. But it has been really, really amazing. Thank you very much. Oriana, if you're there. Sorry, Byron.
No. I just wondered how warm it is in Santiago versus the snow here in Boston. We're jealous.
In the middle of summer there. So
exactly,
I'm here in Boston, but yeah, it's around 30 degrees, but Celsius. I don't know, it's around 80 85. Or 85, something like that. Yeah.
Okay, I want to visit. I want to visit again.
Thank you again for this amazing presentation. It has been extremely useful to understand how the US system works, the challenges and advantages of the different states as well. I think we have a lot to think about and decide the best way to help all this participants of ChileMass Emprende, and thank you so much for your support. It's really, really useful to have a better understanding of how to protect our ideas, our patents, our trademarks, copyrights. It's somewhat similar to what happens in Chile, but is very important to know how to use the US system in the ways we want to promote our entrepreneurs. So thank you very much.
Great. Again,
thank
you.
Again,
good luck. We look forward to hopefully seeing some of you in the fall. Cheers.
Yeah. Thank you. Thank you so much. Jimena, she wants to say a couple of announcements, very, very short. In Spanish, Jimena, you can say it for the next meeting.
Gracias, Fernanda. No solo recordarles que la próxima semana tenemos nuestra office hour y vamos a estar con el equipo de Moonshot. Creo que es muy importante que participen para que disipen las dudas. Vamos a tener nuestro próximo webinar grabado. Les voy a enviar un mail con toda la información, así que por favor estén atentos y los esperamos la próxima semana. Muchas gracias.
Thank you so much, everybody, especially.
Chao, saludos.
Chao a todos.
Bye.
Bye.
Chao, gracias.
Chao, gracias.
Chao, gracias.
Chao. Chao, Fernanda.
Chao.
Chao, gracias.
Tengan buen fin de semana.
Chao.
Chao, equipo. Voy a colgar ahora.
Gracias, Fernanda.